Did you get appointed, Mr. Williams?
Yes, Your Honor.
Great. I wanted you to look at probable cause to see if you guys had any issues with it. That's why, or wait, no, maybe that was another case. Okay, tell me.
We were approaching, there's a MOEP and bond conditions that have no contact. The parties no longer live together, but they work at the same place, and there's a chance that their schedules could coincide with each other. State's okay with no threatening and harassing, but.
Have you reached out to the complaining witness? Do you
Yes,
know?
so, I mean, she's not on board, regardless, but I confirmed that they don't live together, so my suggestion was to have no threatening or harassing that way.
This right here is a classic bond modification debate. Judge Fliescher is trying to balance workplace logistics with victim safety. But here's a legal insight. No threatening or harassing contact isn't just a vague phrase, it's enforceable, and violations can lead straight back to jail. What do you think? Should people with past issues be allowed to work together if they're no longer living together?
Both of them can work.
And I want to make sure that she's, protected, that she doesn't have any kind of fear.
Yeah, she's not really concerned, from my understanding, but I would suggest, just keeping the residency restriction so that, because they don't live together,
Mr. Williams, come up.
and then just, keep the no threatening or harassing contact for that purpose.
Good morning. So your lawyers asked for me to modify your bond conditions to say no threatening or harassing. I will acquiesce, but you have to.
Oof, Judge Fliescher just dropped a serious truth bomb. It's not what you think is threatening, it's what they feel. That eyebrow raise, that sarcastic smirk, it can count. In legal terms, perception often outweighs intention. Question 4. You guys, have you ever been in a situation where someone misunderstood your actions as aggressive?
Understand what is threatening or harassing. Doesn't matter what you think. It's what she perceives. So if I'm going like this, is that threatening or harassing? It most certainly is, and it can get you in trouble. Exactly. I don't know what kind of relationship you have with this person, but if it's the type where you're constantly butting heads, you got to be careful. Mm-hmm. There are many, many vindictive people in this world, and you never know if all they got to do is call, hey man, he's doing this, he's doing that, and then you're going to end up back. So you got to be careful. Mm-hmm. You understand? Mm-hmm. Okay. So the only thing I'm doing is I'm modifying the conditions so no threatening or harassing contact. The residential restriction will still apply. So you cannot go to the house listed in the order for protection. Any more questions, anything?
No, Your Honor.
Okay. All right. Good luck.
Does you want me to refile that? Because I know the language that's typically in there.
Yeah, I would, just in case. So it's like nice and clean. Yeah.
That's good. I'll file that now.
Thank you, Judge.
Oh, and no weapons too.
Yes, sir.
Okay. Mr. Camacho, you're charged with failure to stop and give information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 7th, 2025, officers were dispatched to Hardy Road in Harris County, Texas, in regard to a minor crash, failure to stop and give information call. Upon arrival, the officer spoke with the complainant, who was also in police uniform. The complainant stated he was driving on the freeway when another vehicle got into his lane and cut him off to make the exit. The defendant got over and hit the front right panel of his truck with the back driver's side of the defendant's vehicle. The complainant followed the defendant, who had his hazards on, but the defendant did not pull over. The complainant continued to follow the defendant's vehicle until the 911 operator told him to stop following. The complainant gave a description of the defendant's vehicle, and a license plate number to the dispatcher. The complainant pulled over and waited for the officers to make a report with an estimated damage of $2,000. The officers ran the license plate and found the vehicle registered to an address on Skinner Road, and the officers traveled to the location and met with the defendant and his father. The officers were given consent to enter the property to look at the vehicle and observe damage. The defendant stated he was crossing the lane to get over because there was an opening and that the truck accelerated and hit him. The defendant stated the complainant already hit him and was close behind him, so he kept going. The defendant stated he turned down his street and the complainant kept going. The defendant's address is approximately 7 miles from where the accident occurred.
Okay.
So, Judge, if I may, the complainant was only stopped following him while he had his hazards because he was told on the 911 call. And also, I see on the summary that when they run his license plates, license plate GS 9711 is missing a letter. License plates are usually 3 letters, 3 and 3 numbers. So I'm not sure how running the license plates will go to his house. And additionally, if the correct license plates were also run.
This is where it gets murky. License plates don't match, yet the defendant was still found. This raises questions about procedural accuracy. If the wrong plate was run, could that be grounds for suppression later on? If you were the defense attorney here, would you push for a formal hearing or accept the probable cause as
then it would actually show that he's not the owner of the vehicle. So I'm not sure how they were able to identify.
Well, somehow they got to the house, right?
Yes, Judge, they ran it and they got to an address and they went there and met with the defendant.
And then he states that he was driving, right? And the collision occurred, and then he took off. Your license plate, I have no idea. I mean, did they have the full license plate or did they not?
Your Honor, at this time, I don't know. The DIMS just states, as counsel said, just GS 9711. So I don't know in the full offense report if it says the full license plate number, but either way, they ran a license plate and they returned.
Somehow they were able to get it to him. I don't know. I mean, if you discover something later that's different, come back and we can revisit probable cause. I'm happy to do it at any time.
Yes, Judge. And so the reason I say that is because I have the tags for that vehicle and that's not the license plates that we have on the summary. And that's
I mean,
the reason.
really, we'd have to set it for a formal hearing
Okay, Judge.
because I have to give them time to be able to respond to that as well,
That's
because
fine.
that's more, I mean, this is just a mere probable cause
Your
hearing.
Honor, in the OR, there is the complete license plate. It's the RSG and it continues on. So
I'll check on that, yeah. That's fine, Judge.
So you're saying it was in the DIMS?
in the DIMS, it was missing a letter, but in the full OR, they have the complete license number.
Pull the 911 tapes, see what the 911 tape
We'll wait
says,
for
right?
that,
It may
Judge.
be different, maybe they'll have the whole thing on the 911 tape,
Yes, Judge.
So, Mr. Camacho, I'm going to find that there's probable cause to go forward with your case. Have you run his license? See, he has a valid license.
We're running, Your Honor.
You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. Do you understand?
Yes, sir.
That is a condition of your bond. So if I find that you're driving and you don't have a license or you don't have insurance, I'm going to revoke your bond. I'll put you in jail. No more PR bonds.
Eligible, Your Honor.
You understand?
Yes, sir.
Okay, now you have a lawyer. Good job having a lawyer because you do. I will waive your appearance, but it is your responsibility to stay in touch with her. You don't have to come back to court. She'll let you know when you have to come back to court. All right? All right, I'm going to have you sign a receipt of Victoria. We'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it and then you'll be free to go.
All
right.
right, Judge.
Thanks.